The remedies against the AAEC agreements and the abuse of the dominant position are provided by the Competition Commission of India. It knows that you are been earning money through the anti-competitive segment. If there are any kind of challenges that are going on, then they automatically come into picture and they delete it automatically. If it is a cartel, then there's going to be a direct 10% or 3 times of the turnover every financial year. Good morning and welcome to the second session in Unit 5 Commercial Law, where we are going to talk about the remedies in the Competition Act of the 2002. So as we go here, the first thing that we need to understand, what are the solutions that we have in today's market against the anti-competitive segments or the anti-competitive agreements. So we say that the remedies against the AAEC agreements and the abuse of the dominant position are provided by the Competition Commission of India. So the Competition Commission has come up with specific recovery factors and laws so that they will be able to protect us from this kind of situation. Upon the review and inquiry into the alleged practices, the Competition Commission may pass the following orders. So let's have a quick look into what are the orders. The first thing is that they impose a penalty that is less than 10% or the turnover in the case of preceding 3 financial years. In the case, if it is a cartel, the penalty will be 10% or 3 times the turnover of every financial year and shall continue for the period of continuance of such practices. Now look at the first impact, what the Competition Commission wants to do. It knows that you are been earning money through the anti-competitive segment. So I want to impose a financial situation, a financial penalty on you, which says that the commission will be charging you 10% or the turnover of the preceding 3 financial years in the case if it's an individual person. If it is a cartel, then there's going to be a direct 10% or 3 times of the turnover every financial year. So this is really going to cost the company. Now you may say that the amount of money which I have already made, this is not going to be a serious impact. I'm ready to pay the penalty and I'm going to continue here. Well, then the Competition Commission has got something more for you. Direct the modification of such an agreement or abuse so as to curtail the adverse effect. Now they can pass any order that it may deem to fit. This is where the Competition Commission comes with a real factor, comes with a real challenge altogether. What do they say here is that they say it very, very clearly. In case if we find that you have not still gone through the orders, you have not still gone through the cases, the conditions very, very clearly, that means I will have the right to stop you from trading in the Indian markets altogether. So what we will try to do is that we will probably take you out of the market. We will probably take you out of the situation altogether. So this is going to be quite serious for all of us to understand and take it. So this is going to be something where you have to understand and apply it altogether. So this factor, when the Competition Commission comes into picture, the first thing is that they see the financial impact on the institution, try to curtail their movement. If they are not even with that factor, they are not listening to that, then they go to the level where they can even stop you from trading in the Indian markets. Followed by the Competition Commission of India is established under the Competition Act of 2002, and it is a statutory body that has the power to govern, enforce the competition according to penalties. So which means to say that the body is a statutory body which is passed by the Government Act of Parliament. It is like the Company Law Board. It is like any other statutory body which has the rights, which has the jurisdiction power in terms of opposing any kind of anti-competitive agreements. And it goes to the extent where they see that if there is any kind of anti-competitive agreements that are going on, if there are any kind of challenges that are going on, then they automatically come into picture and they delete it automatically. And this was actually done under the Vajpayee government in 2002, where they wanted to establish a very, very healthy competition rule altogether. They wanted to see that India will have an open free trade market where everybody will be given the chance to compete. Basically, when their government was the first, where they had brought in the PPP model, which means to say that private public participation or the private public way of policies which could come into picture. So they wanted the public as well as the private organizations participation in every single factor. So they wanted to bring an open competition phenomenon. Followed by, the commission is composed by a chairman and minimum 2 board members and a maximum of 6 board members. So you will have a chairman followed by 2 board members or maximum of 6 board members. These members are required to have a minimum of 15 years of experience in their related field or in the respective field altogether. So definitely the board is going to compose of very experienced people who will have the capacity to understand what is going on, make a judgment in terms of the scenario, understand the problems, and pass on a clear-cut analysis as how to control this anti-competitive segment and take them forward. The next thing is that its objectives, duties, and powers are enumerated in the Competition Act of 2002, which is clearly given. Its main duty and object is to ensure that the Indian markets maintain a healthy and fair competitive environment, which is very, very important, and is granted the power to ensure such environment, penalize any kind of acts adversely affecting it. So this is very, very important for all of us. Why? Because this tries to make us understand about the factors that are affecting the environment altogether. We say very clearly that these factors should not come into picture. These factors should not be in terms of affecting the market. So they go into the depth of competition. They analyze what is good for the market. They analyze what is exactly needed for the market. And if they find that there are certain things which is going to disrupt the market, which is going to throw away the entire factor, then probably that's what they really make in terms of coming in, and they stop all those kind of illegal activities. With this, I come to the end of this particular session. I hope and believe that all the information provided through this session will be of a great benefit and resource to you. In the upcoming session, we shall talk about the regulations, we shall talk about the activities of this commission, and we shall try to understand how the competitive law has evolved in our country. But until then, stay tuned, stay blessed, and stay enlightened forever. Thank you once again for joining me today on this wonderful session.